Good morning, Ms. Stone. You may proceed.
Thank you. Good morning. Kristen Stone, Assistant District Attorney from Plymouth County on behalf of the Commonwealth. The affidavit in support of the search warrant in this case provided the magistrate with a substantial basis for concluding that cocaine, money, records, and paraphernalia for drug distribution that were associated with the defendant's drug delivery service could reasonably be expected to be found at his apartment.
Why is that? I mean, what is the, I know he was observed, the defendant was observed leaving his home, going to the location, and completing the sale, correct?
That's correct.
Is there anything other than that at all?
Yes, Your Honor.
What?
The reliable confidential informant described a pattern of operation to the detective in this case, and in fact described that he had been purchasing crack cocaine from the defendant in the same manner during the month.
How many times?
He doesn't specify how many times. He
How
says
much amount?
he doesn't specify that either.
Is there anything in the affidavit that describes this modus of operation as being one that's sort of familiar to and unique to drug operations? Any expertise in the affidavit that would take, I call a cell phone, he comes to a location, and sort of suggest that that is actually a recognized modus operandi in the drug business?
I don't believe this particular affidavit had an opinion of the detective that that was something. He didn't explicitly state that in the affidavit. Within his application, he makes sort of a blanket assertion that he believes there's probable cause to find cocaine in those items at the apartment of the defendant. But the fact that the reliable confidential informant says that he's been buying cocaine from the defendant in that same manner during the month immediately preceding the application.
But we don't know how many times during that month the confidential informant did buy.
That's true. But I would also...
But you'd say it's more than once.
I do. I think it's a reasonable inference that if he describes that he's been buying from this defendant in the previous month, it's reasonable to infer that he meant more than one occasion, or he possibly would have said, I bought on this date from the defendant and limited to that one occasion.
I have a question. Even assuming that we should agree with you that Commonwealth has made a case that drugs were stashed in the apartment, what about the motor vehicle? Because would it be reasonable if they were stashed in the apartment that they're also in the motor vehicle?
There could be a reasonable inference that drugs were stashed in both areas.
As I recall, you searched the car.
We did.
Well, but why would they be in the car if they were in the house?
I would suggest to the court that he's using the car to transport the drugs.
Yes, but he would transport them to the sale, make the sale, and then go back and get more.
That's
and
correct.
Keep them on his person.
Well, in order to go back
or if he kept them in the car, he would just keep them for that one sale.
That's right. It's unlikely that he would keep valuables in his car.
And drugs are valuable, so why were you justified in searching the car in any event?
Well, it was a method of transporting the drugs and to facilitate the drug delivery service. So it was an instrumentality of the drug service itself.
Yeah, but it doesn't follow from that that a subsequent search would necessarily disclose the presence of drugs in that mode of transport.
Except the car was what the informant did say was that in however many times these transactions happened, it was car delivery, this same car. So there was a pattern with respect to that car, actually more of a pattern than with respect to the house.
And the car itself also was frequently seen at the apartment, further drawing the inference that the apartment was involved in the drug delivery service as well.
Can we go back to, is it your position that whenever there's more than one sale, that the apartment is fair game to search? Because it's a reasonable inference that the drugs were stored in that setting?
In combination with the fact that with absolutely no notice, this defendant received a cell phone call at the apartment and within 3 minutes was observed leaving the apartment, going directly to the sale, and then returning directly to the apartment. The reasonable inference is that he had a readily accessible stash of crack cocaine in order to fill that order, that demand.
That's the single sale, but I thought you started off by saying the confidential informant purchased from this person, you would say more than once?
That's correct.
And that was the basis for assuming that the drugs were stored in the...
It would not be the sole basis. It would be in combination and reading the affidavit in a whole, that in addition to the confidential informant telling the detective that he had been purchasing that way, describing the manner that he did that, he then bore that out in the controlled buy, which was well supervised.
Going back to the facts of that buy, remind me, the car arrives at the location. Does the confidential informant get into the car?
The defendant gets into the confidential informant's car.
Oh, the defendant gets into and takes the cocaine out of his hat?
That's correct.
Okay.
And then returns to the caravan and drives directly back to the apartment.
In regard to a previous question I think you asked, apparently the confidential informant stated that he had been buying crack cocaine from Dragon for the past month. He didn't say how many times, did he?
He did not.
But he did say for the past month, suggesting that it's at least more than once.
And he did describe the process and the method that he would do that, and it was corroborated by the police using the confidential informant to make a controlled buy in exactly that manner.
Ms. Stone, to follow up on the slightly different version of Justice Island's question, there are many drug sales where somebody gets in a vehicle and goes and delivers the drugs and then goes back. Does that mean that in every case where a vehicle is used, this, if we ruled in your favor, this would stand for the precedent that you can automatically get a search warrant for the vehicle as well?
No, I think the facts of this affidavit,
What makes this different?
the fact that there was no notice required.
No, that's the house. You've answered that.
Yes.
No, I'm talking about the vehicle. You said he used it to transport the drugs, gets the call, gets in the car, and I'm asking you whether if we ruled in the Commonwealth's favor, does that mean that every time a car is used to deliver drugs, the vehicle can be searched?
I think similar to the apartment, the analysis would be if the car is part of the pattern and the method, if it's consistently used to facilitate the drug deliveries.
There's nothing to show that there were drugs in the car other than what was this particular buy, correct? It wasn't as if he got a phone call and, he was observed on the street and immediately got into the car without going anywhere and went in to deliver drugs.
I think it would have to be a case-by-case basis if there was information that indicated that the defendant was making multiple deliveries. That would...
But doesn't there have to be some connection between the car as something other than a mode of transportation? Doesn't there have to be some indication that he reached into the glove compartment or stuck his hand under the back seat and pulled the drugs out? I mean, because otherwise, if the drugs are in his pants pocket or his jacket pocket, he gets into a car. Every time he uses that car, it seems to me that the answer to the Chief Justice's question is, if from your perspective, yeah, we are entitled to search the car every time because he's used it in the past.
If it's consistently part of an ongoing drug delivery service, I guess my answer is yes.
But how can you infer, as the appeals court says nothing in the affidavit from which there was nothing in the affidavit from which the magistrate might infer that drugs were kept in the vehicle.
And if
I mean,
could just-
you're searching for drugs because they are kept there.
If I could, the focus of our appeal, the Commonwealth's appeal, is the nexus to the apartment.
Right, you didn't even take
I did
further
not.
appellate review on the
I
car
did not.
search. The car search is
So
really
you're
not
not
before
placing
us.
that point?
I am not.
No,
Okay.
car search.
The focus of the Commonwealth's appeal was on the nexus to the apartment. And again, where the defendant was readily available to fill that order that the CI made within 3 minutes and drove directly to that sale and then directly back to the house, it's reasonable for the magistrate to infer that the apartment is connected to the drug delivery service and that not only did he have a readily accessible supply in order to satisfy that demand of the CI, that he went directly back to the house, and that he would have brought the fruits of the transaction, the sale that he just made, back into the apartment as well. And by that one carefully controlled and supervised buy, he demonstrated that his apartment was connected to this drug delivery service, and it was reasonable to infer that any sort of business-type records would be maintained there, any sort of billing information for the cell phone, any monies that he might have taken from that particular buy or any other buys made in the drug delivery service would be found at that apartment. It was also reasonable for the magistrate to infer that when he returned, he was ready, willing, and able to fill other short-notice demands for crack cocaine.
And there is no evidence that this defendant was selling to anyone else. You're suggesting simply the fact that the confidential informant said he had made purchases before. It's reasonable to infer that, of course, he was selling to other people.
I would suggest, yes, that this was not his sole customer.
Just because he sold drugs before to the confidential informant? I mean, what's the basis of that?
That he recently, within the past month, had a pattern of selling to this
Pattern, we don't know how many. The confidential informant hasn't told us anything about whether he bought drugs once before from this fellow or 20 times before.
But we don't need to believe that he sells to other people. I mean, it would be enough to have sold to this person and to have gotten the drugs from this apartment if there's a nexus between the two.
I agree.
Ms. Stone, what do we do with Smith, if anything? Is Smith just incorrectly decided?
I think that the facts of this case are distinguishable from Smith, and so the court could decide the sufficiency.
What's the most distinguishing fact? What's the most important distinguishing fact, would you
Well,
say?
as O'Day mentions, there is police corroboration. And the police corroboration of this pattern, in addition to the fact that
You
there's
keep
a pattern.
saying pattern. Be very careful, because we have to assume that there was perhaps 2 buys at most, right?
Before the present one.
No, 1 buy before the present one.
No, the confidential informant said he'd been buying during the past month from this guy, so it would seem to be more than 1 buy before this one, it would suggest.
A method, if you will, of operating that this defendant used, which the CI describes as being to place a telephone call, to place your order, to then receive directions of where to meet, and then to go to that spot.
If you're placing a telephone call, you do not necessarily know where the person is, correct?
That's true. The nature of cell phones.
You don't know.
You
So
do not know.
we don't know whether for the prior 2, 3, or 20 buys, this defendant had been at some other address.
That's true. But
So
on
for all-
the
for
carefully
all we-
supervised, the controlled by using the confidential informant, he is
So
at
for-
the apartment when he receives the telephone call and leaves 3 minutes after that call to make the
Yes.
sale.
Isn't that the big difference between this and Smith? I mean, the one sale in Smith where the defendant came from the apartment, there's no indication as to timing.
That's right. The immediacy of this sale from the apartment and the fact that the defendant on the same transaction leaves the apartment and returns to the apartment distinguishes it factually from Smith.
Can you please correct me if I'm wrong? I thought that in the facts of this case, the confidential informant had stated that he had made a phone call to the defendant, and the defendant left his apartment immediately after the phone call to consummate the buy.
Yes.
That's
That is true. I
That's
heard
No,
you say
I'm
just
sa-
a minute ago that the confidential informant did not see him leaving his house immediately because he made the call from a cell phone.
Well, the
I
CI
think-
didn't, but the police saw him leaving.
That's
immediately
correct.
after.
The confidential informant had already headed
All
to
right.
the meet location,
Okay.
but the police officers were conducting surveillance at both locations.
Yep.
So what does the U.S. Supreme Court say about this, if anything?
I'm not sure I can answer that.
Okay,
Sit down.
it's a fair answer.
Put it this way, you're not relying on any United States Supreme Court precedent.
I was not. I tailored it strictly to the Commonwealth.
Article 14 provides greater protection to
It
the
does,
police.
in fact. I suppose I figured if I could satisfy that, I'd be safe. But my brief does heavily rely on Commonwealth versus Luthi that was recently decided, and as well Commonwealth versus Pena, which I believe is the argument after mine, where the factual scenario is very similar, and the court found that there was a sufficient nexus between the criminal activity and the apartment from where the drug delivery service was taking place out of. If there are no other questions, I would conclude with, again, suggesting to the court that the magistrate had a substantial basis to conclude there was a nexus between the defendant's criminal activity and his apartment, and respectfully ask that the court reverse the order suppressing the evidence seized from the apartment.
Thank you, Ms. Stone. Good morning, Mr. Klowski.
Good morning, members of the court. Attorney Joseph Krosky, Jr., on behalf of the appellee, Jose Medina, I would start off by stating unequivocally that Judge Chin in the trial court and then the appeals court of this Commonwealth got it right in that the affidavit did not establish a substantial basis for the magistrate to conclude that the items sought in the place to be searched would be found at the time of the execution of the search warrant.
Why not?
The government has done, and I would submit that they've taken great license with this affidavit, and has created an illusion that there was some sort of method of operation. If you read the affidavit, and again, we can't judge anything by its quantity, but it's a very thin affidavit, and in this case, I think it does reflect on the quality. The government's has done a much better job of trying to color the affidavit than the affiant did. The confidential informant that gives information to Detective Corey does not establish a pattern other than to say he would call Mr. Medina on a cell phone and then purchase drugs. He doesn't say that he would call him at his home. He doesn't suggest that Mr. Medina would answer the phone and state that he's at this address in Brockton and would be there in a short time. He doesn't state that he's ever been to the address. He doesn't state that he has any information that Mr. Medina stores drugs or keeps drugs at the address. He doesn't state in the affidavit that he knows Mr. Medina has a large quantity or a readily available quantity kept at
Mr.
23
Krosky,
Clinton
but
Avenue.
Isn't the standard probable cause? And yes, he might keep them in some locker somewhere else, or he might keep them in a factory, or he might keep them somewhere else. But at least one time we know that a call was made to the defendant at his apartment, and he left immediately thereafter and went and made the sale. Now, wouldn't that at least establish probable cause, not proof beyond a reasonable doubt, certainly?
If you're talking about a geographical and timely nexus that 5 days prior to the execution of a search warrant, Mr. Medina on one single occasion was seen leaving from that apartment to make a controlled sale with an unspecified quantity of cocaine, my answer to you, with all due respect, would be no, that does not establish probable cause as it relates to the nexus.
Why do you say 5 days? Because as I read the affidavit, on September 14th was the controlled buy, and the affidavit was signed on the 15th and issued on...
Executed on the 19th.
I know it was executed on the 19th, but we have to judge this, I guess, by the time that the magistrate saw the warrant, the affidavit, and issued the warrant, and that would be the day after.
Well, no, I believe the standard is at the time that they're going to search that home, is there going to be a nexus, probable cause to believe that drugs are going to be in the apartment at the location at the time they execute the search warrant.
All right, maybe there are 2 dates that we have to deal with that.
Certainly, but what I think that the Commonwealth has done is a very skillful job of trying to bootstrap this one single controlled buy onto some sort of quasi-method of operation that, quite frankly, I don't find in the affidavit, and that Detective Corey never went to any pains to opine that there was a method of operation or that this was a delivery service, and that his opinion was the prior buys would have been similar to this.
When you boil down what the confidential informant said, he said that he had been buying from the defendant for the prior month. He said that he called and it was delivered. Didn't he say that?
I think that's paraphrasing, but to that extent, yes. However, what he didn't say, like this case, he would call and moments later Mr. Medina would arrive, and that avoids the real problem here for the government, the nexus issue. He had no basis of knowledge of where the drugs were originating from. Where was Mr. Medina located during this one prior controlled buy, second controlled buy? We don't know. Was it in the morning? Was it in the afternoon? Was it at night? He doesn't even state that he used that automobile to actually make the controlled buys. So that cannot be bootstrapped into this one controlled buy. And if you look at the Luthi case,
He did just one control buy? Am I?
he only did one controlled buy. I shouldn't have.
Talking about plural.
I misspoke. It wasn't a control buy. The prior purchases, there is just no information to support the government's conclusion. When I say the government, I'm speaking of the executive branch, their conclusion that this was some sort of pattern of conduct where Mr. Medina would leave his address and go and make this controlled buy. And they do take some liberty in their brief, and they talk about prior buys being consistent with this one. That's not in the affidavit. Now, Judge Chin, who decided this court, has some credibility on this issue because he was the judge that denied the motion to suppress in the O'Day decision. This court, when they reviewed the O'Day decision, upheld the principle of Commonwealth versus Smith that merely leaving on an occasion and going to a sale of drugs does not establish a geographical nexus to that location. There has to be more. Judge Chin called this a carbon copy of Smith in the appeals court, and I would say correctly called it on all four corners with Smith.
Mr. Klosky,
Yes.
what do you make of the Smith's statement that in that affidavit there were 3 controlled buys of marijuana during several weeks, so we know how many, all at locations other than his residence? In other words, in Smith, as I understand it, the buys were taking place. I mean, there was nothing.
Correct. Well, Smith, with all due respect, I believe a fair reading of Smith, they had more information to establish a nexus to the address. It was a Barnstable detective working in conjunction with a drug unit down there, 3 controlled buys. On one of the controlled buys, the first one, they watched him go back to the address, the target address, right after a controlled buy. And on the third controlled buy...
There's no timing. That affidavit has no timing in it.
Well, that's true, but I think a fair reading is they still did surveillance immediately from, on the third controlled buy, from the target address to the controlled sale. And there was 3 controlled buys on that case. So I don't think that the case before this court has more information for a magistrate to draw that conclusion than Smith did. It's important to note that there was nothing from the informant, absolutely no prior information. And look at the surveillance that they did. Detective Corey did surveillance, very limited surveillance, but the one time that he did do it, he watched Mr. Medina leave the address, which might show that Mr. Medina lived there, but he went to a video store. When he went into the video store, Mr. Medina had rented a video. There was no other observations of people going into that target address and leaving for a short time. There was no other sources developed. Detective Corey took a shortcut. He didn't follow that surveillance up. That seemed to satisfy him. He didn't do other surveillance during this. You call it a month-long investigation, but when you look at it, other than this one brief controlled buy, there really was no investigation. And maybe that's because when they did try to do one, they didn't have one single fact other than innocuous details of Mr. Medina's daily life taking place in that apartment.
What about this take on it? Right after completing the sale, Mr. Medina returned to his apartment, or the apartment with which he'd been identified and from which he had left. Why isn't that a basis to conclude that the proceeds of the sale and records with respect to the sale might be at the house? Forget the drugs for a moment, because this warrant goes for things beyond just drugs.
Well, that principle probably would have applied to the Smith decision. What you're left with, I still believe the same principle applies. It takes more. All we have is the fact on one occasion, when Mr. Medina was presumably called by the informant, he happened to be at that address and went and sold an unspecified quantity. Now, the government leans heavily on the Luthi decision. And look, I can disagree with Luthi, as many on my side of the bar might do, but I have to ethically accept that it is binding authority. However, I would state this, that I think it's on the verge of what's acceptable. Otherwise, we're going to erase the law on requiring a nexus completely. But Luthi, I would state, not only is it on the verge, but heavily distinguishable from this case. In Luthi, they had a confidential informant, provided his street name, Milkman. He said that he knew the target, Mr. Luthi, and that Mr. Luthi was selling on a steady basis to others. In Luthi, they did 2 controlled buys, and the experienced detective said that it was a large quantity, and the court relied on the 2 controlled buys portion of it 4 separate times in their opinion, and they also talked about the large quantity because it was reasonable, in conjunction with the opinion of the affiant in the Luthi decision, to believe, because there's a large quantity, that when he was called during the 2 controlled buys, that he would have had a readily available stash amount in that apartment for delivery. There's not one single mention. It would have been very simple for Detective Corey to put the amount in this case so that you could conclude, or he could form an opinion that, look, this was a large amount. This isn't someone who just came from a different location or had a small amount in his pocket. This is part of a stash, or the way this is packaged, in my expert opinion, is part of a greater stash that, in my opinion, people don't travel around with. Would have to be there.
Mr. Krowski?
Yes.
Do you see any difference between this case and the Pena case? And Justice Green's opinion in Pena?
I don't see it significant. I think the facts are very similar. I think, with all due respect, that they got it right in my case, and that they didn't decide Pena
Do you see
correctly.
any distinguishing factors?
I don't. I quite frankly think that the dissent in the Pena case was well written in saying that, other than the fact that a person was at a single location during one of the sales, quite frankly, more is needed. Now here again, Medina, just 1 buy, no quantity, no sales to other, no corroborating observations from the affiant or anyone involved with him in his investigation.
What kind of, no corroboration? What do you mean by that?
Well, look at, Judge Chin decided this case, and he allowed my motion. Judge Chin denied the motion in Commonwealth versus O'Day.
But we have to look at this case.
Right. Well,
Right, but I'm talking about the corroboration this court has in the past said can make up for certain deficiencies. In O'Day, they had the person leaving the target address and going to a bar, but also they had a couple of other things. The affiant took the time to watch that target address over a period of time and noticed people would come in, stay for a short period of time, and leave. And he formed, or he put his expert opinion to state that's consistent with a target address where drugs are kept or stored. He also did an inquiry into the utilities, and they had been putting in the girlfriend's name in the O'Day case, and he said, that's the type of activity. That's a stash house. That's what people in this type of business do. None of that in this 3+ pages is contained in the affidavit before this court.
I agree with that largely, that certainly there was a great deal more in the O'Day case than there is in this case. There's no question. But that doesn't mean that the O'Day case set the floor, or the ceiling, I should say. But if the M.O. is to divorce the stash house from the sales, you would certainly not expect that there would be people showing up at the stash house to make purchases. That's the whole point of this method of drug delivery, right?
That is true.
But you're saying there still needs to be more to corroborate that this method of drug delivery is in fact a method that is existent, or that the defendant is participating in.
Otherwise, the exception obliterates the rule, and the rule has always been that just because someone's involved in the distribution of narcotics, or there's probable cause to suspect they do that, the commission element does not establish the nexus that they're storing the drugs in their house, because what's next? If this is overturned, what's next? we're going to start hearing common sense conclusions from magistrates that, well, he's involved in many sales, so
All right, well, we don't leave common sense at the door. We do suggest that magistrates are supposed to use their common sense in how they look at the entire affidavit.
I understand and I agree with that, but I don't think that supersedes the sacrosanct right to be free from a physical intrusion not supported by probable cause in one's home. And I
So a
think
reasonable suspicion is different than a substantial basis.
correct, absolutely. And sometimes I think the government gets loose with the language and says likely. It is a substantial basis to conclude. And this court asked about the Supreme Court. I do agree that Article 14 gives more rights than the Fourth Amendment, but I do know in Payton versus United States they said there is no other physical intrusion that demands more scrutiny than the intrusion into one's home. And that doesn't matter if it's a lawyer's house in Easton or Weston, or a man named Mr. Medina who happens to live in an apartment in Brockton, Massachusetts. He still had that same constitutional right that protects us all. And I, with all due respect, don't see how that you can overturn the well-reasoned decision of Judge Chin and the appeals court without completely stating that Smith is no longer the law. I just don't see the distinction between Smith in this case, nor did the appeals court, nor did Judge Chin. So for all those reasons, this case has been scrutinized on 2 prior occasions. I respect the court's decision, but I think that the prior decisions in this matter should stand.
Thank
That's
you,
all
Mr.
I have. Thank you.
Mr. Klasky.